This is part 49, and in this part we intend to deal with section 87, section 88, section 89, and to understand these sections and many more sections as far as Indian Penal Code is concerned, we must know when you say that the act is done with the consent of an individual, what do you mean by valid consent or the consent which is intended by the provisions of the Indian Penal Code? And hence, as it was made very clear, generally in order to know a particular term we refer to general explanations. But this is an exception as far as section 90 of the Indian Penal Code is concerned, that defines what do you mean by consent, or what do you mean when it can be said that it was a valid consent or the consent which is intended by the provisions of the Indian Penal Code in the negative form. Now, if you remember, when we dealt with section 92 of the Indian Penal Code, doctor takes a decision to perform operation without consent of the patient. There is no time for the benefit of the patient, and if the operation is unsuccessful, doctor is not liable because doctor is protected as per section 92 of the Indian Penal Code is concerned. Now, along with this, now this is a time where we shall be dealing with two sections, section 88 and section 89, where the act is done with the consent of the person with which we shall be dealing, and then one more section where you give consent for some act, and if that act results into harm to you, as in case you play a game, at the time of playing a game like wrestling or a game like boxing, there is every chance or possibility that the act, I mean the blow which is given or the punch which is given or the hook which is given may result into harm to you, but then you can't go to the court of law. And if you go to the court of law, the person will say, well, I am protected as per section 87 of the Indian Penal Code is concerned. So these are the sections with which, I mean, this is not just the introduction, we shall be dealing with these sections, but first of all, and then during course of time, I had mentioned to this section, namely section 90 of the Indian Penal Code, but we will refresh our memory as far as what do you mean by consent known to be given under fear or misconception, and then we will try to understand this under 5 different heads. Now it says, it starts with the wording, a consent is not such a consent. So when you say when the act is done with the consent, it is not such a consent as is intended by any section of this code. If the consent is given by a person under fear of injury or under misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception. In other words, if the consent is given under fear of injury, that is not at all a valid consent. Or if the consent is given under a misconception of fact, that is not at all a valid consent. And then in that case, if the person, one who is doing the act, he knows or has reason to believe that the consent was given in consequence of such fear or misconception. Now I don't think, because we dealt with this at the time of discussing section 378 of the Indian Penal Code in detail, what do you mean by injury? You obtain a consent under fear of injury. Injury has got meaning as it is defined by section 44 of the Indian Penal Code. Reason to believe is defined by section 26 of the Indian Penal Code. So if the consent is given under fear of injury, or if the consent is given under misconception of fact, and if the person doing the act knows or has reason to believe that the consent was given in consequence of such fear or misconception, that is not at all a valid consent. Secondly, now, next part it says consent of innocent person, and it says if the consent is given by a person who from unsoundness of mind or intoxication is unable to understand the nature and the consequence of that to which he gives his consent. In other words, if the consent is given by a person who is a person of unsound mind, or if the consent is given by a person who is intoxicated, and because of the unsoundness of mind or intoxication he is unable to understand the nature and the consequence of that to which he gives his consent, that is not at all a valid consent. And what do you mean by person of unsound mind or what do you mean by intoxication, with which you dealt when we dealt with general exceptions. So if the consent is given, why it is not valid consent? It is not valid consent because the person is unable to understand the nature and consequence of that to which he gives consent. So that is as far as first of all we dealt with consent given under fear of injury, 2. Consent given under misconception of fact, 3. Consent given by a person who is a person of unsound mind, consent given by a person who is intoxicated, and the last part, now it says, of course everything has been qualified. If the person, for example, person is a person of unsound mind and is able to understand the nature and the consequence of that to which he gives consent, then in that case it will be a valid consent. But otherwise, if he is unable to understand, the person because of intoxication, person because of unsoundness of mind is unable to understand the nature and the consequence of that to which he gives his consent. And lastly, now we come to the last part as far as section 90 of the Indian Penal Code is concerned, which says, unless the contrary appears from the context, if the consent is given by a person who is under 12 years of age. So in other words, consent given by a person who is under 12 years of age is not valid. That does mean consent given by a person who is above 12 years of age is valid, but this is subject to what? This is subject to, it has been qualified by saying, unless the contrary appears from the context. And then if you refresh your memory regarding the sections with which you are dealt, refer to last clause as far as section 375 of the Indian Penal Code is concerned, which defines the offence of rape. It says with or without her consent when she is under 16 years of age. So the consent given by a girl when she is under 16 years of age in order to have sexual intercourse will not, absolve the person, but because it is not at all a valid consent, because this is the contrary that appears in the context. Similarly, read section 361 of the Indian Penal Code, with which you are dealt as far as kidnapping from lawful guardianship is concerned. In case of male, if he is under 16 years of age, or in case of a female, if she is such a minor is under 18 years of age, as long as he or she is in the keeping of the lawful guardian, consent given by such a person is not at all valid consent. And then, as if you remember, there are other sections to which we had a reference. For example, if you refer to the fifth exception as far as section 300 of the Indian Penal Code is concerned, where if you kill somebody with his consent when he is above 18 years of age, then naturally that will amount to the offence of kidnapping from lawful guardianship as defined. That will amount to the offence of say culpable homicide not amounting to murder, provided that you have killed somebody with his consent when he is above 18 years of age. So age plays very important role, and then unless there is a contrary which appears in the context, in general, consent given by a person who is above 12 years of age is what is known as a valid consent. With this now, we start, this is just revision as far as what do you mean by valid consent, or the consent which is intended by the provisions of the Indian Penal Code is concerned, as compared to what? Now, not time every now and then for you to compare, but refresh your memory regarding what do you mean by free consent as far as law of contract is concerned. The terminology and the meaning is entirely different. As far as law of contract is concerned, there we say free consent. Which is free consent? Which is not obtained because of coercion, undue influence, fraud, misrepresentation and mistake. So this has nothing to do as far as this consent is concerned, valid consent or the consent which is intended by the provisions of the Indian Penal Code. With this now, we start discussing now section 87, which says act not intended and not known to be likely to cause death or grievous hurt done by consent. And what the section says? Nothing which is not intended to cause death. So when intention is to cause death, the person may be liable for culpable homicide or culpable homicide, because the section starts with the wording whoever causes death by doing an act with the intention of causing death. So there is absence of intention which is not intended to cause death or grievous hurt. So the intention is neither to cause death or grievous hurt, and which is not known by the doer to be likely to cause death or grievous hurt. There is no knowledge on the part of the doer that this act will result into what? this act will result into death or grievous hurt, is an offense. That is not an offense. By reason, why it is not an offense? By reason is not an offense by reason of any harm which it may cause, or be intended by the doer to cause to any person above 18 years of age. Again, age. Here we talk about above 18 years of age who has given consent, whether express or implied, to suffer that harm, or by person of any harm which it may, or by reason of any harm which it may be known by the doer to be likely to cause to any person who has consented to take the risk of that harm. Now this is, general, this section comes into operation where there is a consent which may be expressed or which may be implied also. When you play a game like cricket, when you play a game like football, when you play a game like volleyball, when you could play any other game, or maybe boxing, or maybe wrestling, whatever it might be, there in that case now, at times, the bowler has bowled the ball and the batsman strike the ball and hits the ball. When he is trying to take a catch, there is fracture as far as his finger is concerned. Now, can it be said that the batsman is liable for the offence of voluntarily causing grievous hurt defined by section 322 of the Indian Penal Code? The answer is in the negative, because section 87 is an exception. Why? Because this was not the bowler, the batsman never struck the ball, he never intended to cause death or grievous hurt, and which is not known, it was not known by the doer to be likely to cause death or grievous hurt. Now, is an offence by reason of any harm which it may cause. So it may cause harm, no doubt about it, but intended by the doer to cause any person, and while he was above 18 years of age, who has given consent, whether express or implied, to suffer that harm, or by reason of any harm which it may be known by the doer to be likely to cause to any person who has consented to take the risk of that harm. So this is, the importance of section generally, but there cannot be, mind well, the illustrations which are given, A and Z agree to fence with each other for amusement. This agreement implies the consent of each to suffer any harm which in the course of such fencing may be caused without foul play, and if A while playing fairly hurts Z, A commits no offence. But if there is a prize fight, A has a sword, B has a sword, and both of them say, we will keep here, this amount, and one who wins will take away the amount, and he, with the help of the sword, he cuts somebody, which results into his death. Price, this is not allowed, because by using that, your intention is to cut, and intention is to cut means cause death or cause grievous hurt. So that is not at all allowed as far as section 87 is concerned. You cannot, mind well, we have learnt one thing: if you kill somebody with his consent also, then that will amount to the offence of culpable homicide, not amounting to murder, because it falls under fifth exception as far as section 300 of the Indian Penal Code is concerned. So that is not an intention. But while you play, as in case, for example, play a game like hockey or football, whatever, generally this section comes into operation as far as the games are concerned, or when these are the cases where we refer to, where if the ingredients as far as section 87 of the ingredients are fulfilled, then that will not amount to an offence. With this now, we proceed to section 88. And what is section 88? It says, act not intended to cause death, done by consent in good faith for person's benefit. And it says, nothing which is not intended to cause death is an offence by reason of any harm which it may cause, or be intended by the doer to cause, to be known by the doer to be likely to cause to any person for whose benefit it is done in good faith, and who has given consent, whether express or implied, to suffer that harm or take the risk of that harm. So this is when surgeon takes a decision to perform operation with the consent of the patient, and patient dies. The surgeon is not at all liable for the offence of murder, because his case falls under section 88. Why? Because he has, first of all, he had acted in good faith. That is what is required. And in order to understand good faith, you should have, for example, when the surgeon performs the operation, he must perform operation in the operation theatre. It must be performed with the help of the sterilized equipment. He must perform the operation where there is a supply of oxygen, there is supply of blood also. Everything, whatever care is required, because refer to section 52 of the Indian Penal Code. And what is section I mean? If you refresh your memory as far as section 52 of the Indian Penal Code is concerned, that clearly lays down that nothing is said to be done or believed in good faith which is done or believed without due care and attention. So this is due when you are a doctor and you are performing the operation, whatever is required, everything is required to be done in good faith, then you are protected, doctor is protected as far as section 88 of the Indian Penal Code is concerned. If he is not protected, if he doesn't do the act, I mean in good faith, then may not be liable for the offence of culpable homicide, but may be liable as far as section 304A of the Indian Penal Code is concerned. So here, when nothing which is not intended, doctor never intend to cause death, is not, and hence where intention is not to cause death, it is not an offence by reason of any harm which it may cause or be intended by the doer to cause, or to be known by the doer to be likely to cause any to any person for whose benefit it is done in good faith, who has given consent, whether express or implied, to suffer that harm or take the risk of that harm. So that is not the person is doctor is protected as per section 88 of the Indian Penal Code is concerned. With this now section 89, last section as far as general exceptions are concerned. And what is that? Act done in good faith for benefit of child or innocent person by or by consent of guardian. And it says nothing which is done in good faith for the benefit of the person under 12 years of age, because we have read last clause of section 90 which says unless the contrary appears in the context, consent given by a person under 12 years of age is not at all valid consent. So when something is required to be done with respect to the child who is above under 12 years of age, whose consent is not valid consent, what the section says, nothing which is done in good faith for the benefit of the person under 12 years of age or of unsound mind or by consent either express or implied of the guardian or other person having lawful charge of that person is an offence by reason of any harm which it may cause or be intended by the doer to cause or be known by the doer to be likely to cause to that person. So when the act is done, the consent of the child who is under 12 years of age is not valid. So here whose consent is required? By the consent either express or implied of the guardian or other person having lawful charge of that person is an offence. So this is done with respect to whose consent? By the consent of the guardian or by the consent of the person having lawful charge of that person. So that will not amount to an offence. Other ingredients remaining the same, the act must be done in good faith accordingly. So if a child is required to be operated whose age is 9, consent, a doctor has taken the consent of the guardian and takes a decision to perform the operation, and now if the operation is unsuccessful, which results into death of the person, then naturally, as the illustration saying, A, in good faith for the child's benefit without his child's consent, has his child cut for some stone by surgeon, knowing it to be likely that the operation will cause the child's death, but not intended to cause the child's death. A is within exception is as much as his object was the cure of the child. So this is when the act is done. But this section, namely section 89, is subject to proviso. And what is the proviso? It's a proviso provided first that this exception, when we are talking about this exception, shall not extend to the intentional causing of death. So when the death is caused with the intention, it is not to the attempting to cause death. So this is first proviso, that this exception shall not extend to the intentional causing of death or to the attempting to cause death. Secondly, that this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death for any purpose. So that this exception shall not extend to the doing of anything which the person doing it knows to be likely to cause death. He may, he knows that it is likely to cause death. When it should be done for the purpose of other than preventing of death or grievous hurt, or the curing of any grievous disease or infirmity accordingly. So this can be, you may know that if the operation is unsuccessful, that may result into death of the person. But then this is done in order to what? In order to prevent the death or the grievous hurt or the curing of any grievous disease or infirmity. Thirdly, it says that this exception shall not extend to the voluntarily causing of grievous hurt or to attempting to cause grievous hurt unless it be for the purpose of preventing death or grievous hurt or curing any grievous disease or infirmity. And lastly, it says that this exception shall not extend to the abatement of any offense. It will not extend to abatement of any offense, to the committing of which offense it will not extend. So this is this section has 4 provisos accordingly, and hence the act, if the act is done in good faith, if it is done for the benefit of the child or as the consent given by a person is a person of unsound mind, that is insane person, is not at all valid consent, there must be consent on the part of the guardian, or there must be consent on the part of the person having lawful charge of that person. And if it is done, the consent may be expressed or it may be implied accordingly. And if it is done, then whatever may be the result of the act which is done, subject to the provisos, will not amount to an offense as far as section 89 of the Indian Penal Code is concerned. With this, we have finished with general exceptions. Now, after general exceptions, that is right from section 76 up to 106 of the Indian Penal Code, we come across a chapter, namely what is known as an abatement. So, but abatement we have dealt in the past, right from section 107 up to 120 of the Indian Penal Code deals provision as far as abatement, where we have learned abatement is not an offense, but abatement of an offense is an offense accordingly. With this now, we have also dealt during the course of our lecture by section 120A of the Indian Penal Code, which defines the offense of criminal conspiracy. That also we have dealt with. And now this is a time where we start discussing right from section 121 up to section 130, and these are the offenses against the state. Now, as you go on reading the offense, now there are some chapters where you read the offense and you understand the offense. So in that case, I may read, no doubt about it, but it may not be necessary for me to explain in detail. Now, as far as this chapter is concerned, barring only one section, namely section 124A of the Indian Penal Code, which defines the offense of sedition, we will have to have a discussion, no doubt about it. What that we will do, or that we will continue, no doubt about it. Otherwise, as far as next part of our next lecture is concerned, we shall be dealing right from section 121 up to section 130, dealing with offenses against the state. Do refresh your memory. In the past, at the time of discussing some topic as far as Indian Penal Code is concerned, I had drawn your attention to this chapter, namely offences against the state. When, how, why? These are the questions where you must try to find out the answer before we proceed to this chapter, right from section 121 up to section 130. Now, offences in the next chapter, chapter 7, deals with offences relating to Army, Navy or Air Force. Again, right from section 131 up to 140 are the sections which deal with what? Offences relating to the Army, Navy or Air Force, where we read the section and we understand it accordingly, with which we will continue as far as our lectures are concerned.